This is Erica Merrill, and I'm the founder of Perfect Legal Video. I am very excited to have with us today Attorney Nicole Reeves Lavallee. She has a family law firm out of Worcester, and she always comes to us with very interesting topics. Today, we're going to be talking about marital assets, and I can't wait to hear about this because I know it's a huge concern for a lot of people. Welcome to the show today, Nicole.
Thank you for having me.
You're welcome. So why don't you just define, we always like to start with a definition. What is a marital asset?
Marital asset is everything. Long and short of it is it's everything that you own. So it could be the house, it could be the bank accounts, it could be the retirement accounts, it could be your furniture, your jewelry, everything that you own when you're married is technically considered a marital asset. So we start with the presumption that every asset that is in your name or in your spouse's name is a marital asset.
I mean, I think that can be a scary thing for people when they're going through a divorce. What about the assets you have before you get married?
Well, that's why I started with everything is considered a marital asset. Now, let's see if we can exclude some things. So, if you own something premarital, then it may be considered a premarital asset and not subject to division. The question is, what is that asset and whether it's been growing or not. So, prime example is my mother passes away and she leaves me jewelry and that's worth $10,000. Chances are the value of that $10,000 jewelry hasn't increased over the next 10 years of my marriage. So that's probably going to be considered an exempt thing that is not a marital asset. Now, we take another example of your house. So I owned a house prior to my marriage. At the time of the marriage, there was $50,000 in equity in the house. At the time of the divorce, there's $100,000 in equity in the house. That means that $50,000 is marital assets, and the other $50,000 may very well be non-marital assets. But we do have to take a look at the big picture of the length of your marriage, the conduct of the parties. So we're going to start with the presumption that probably that $50,000 is excluded. It may not be excluded, but we have to look at the facts of each particular case.
Now, when you're talking about a house, that's a great example. And I know that when you're assessing the asset, like such as a house, sometimes people have different opinions as to what they're worth. What do you do? And I know this is the same case with businesses.
It is. And you're going to look at, again, what is that value? So each person's entitled to have an appraisal or do some kind of evaluation on an entity. So if it's a business, they're going to do a valuation, a forensic evaluation. If you have retirement accounts, again, those are kind of set in stone, but maybe there's other things that are going on. Maybe it's stocks that are going to fluctuate. So any of these things, you're going to have somebody look at it. Your side is going to say it's X, their side is going to say it's Y. So the real question is, one, can you agree on one person doing those numbers and you live by those numbers? Or in the alternative, are you going to have dueling, competing appraisals where two people are going to go in and testify and one person's going to say it's 100,000, another person's going to say it's 200,000, and then the judge is going to go, I don't really give a damn, sell it. So the question is, again, where are we going to be? You really got to look at, can we narrow it down? If we're $10,000 apart, I'm going to tell you, split the difference and call it a day. Obviously, if we're $100,000, then we're probably going to go to trial. But at the end of the day, the judge's only remedy in that situation is to sell the asset, in which case it will get fair market value, and it is what it is. So again, you want to look at those numbers and figure out, is there a way that we can compromise and come up with a number that works for both parties?
Wow. I had no idea that that's what the remedy was if it goes in front of a judge. That's very interesting. I mean, I've heard you say, hey, we'll split the difference sometimes, but that is very interesting. I guess that's one reason why you really want to try to come up with a solution without going to trial.
Absolutely. And again, I think it goes back to, what does that number look like? Because the judge, if there's only one expert, then obviously the judge may very well say it's the expert opinion. But dueling experts, the judge has no idea. The judge isn't going to split the baby. The judge is going to go sell, and that's the alternative.
So I'm a divorced woman, thanks to you. And when I was doing a lot of dating, I went on some dates with people that said, hey, my stuff was held in a trust. And so that is totally out of the picture when it comes to the division of assets. Is that true? What if the assets are in a trust?
I have fought many cases that deal with trust. We really have to look at what kind of trust it is. So is it a revocable trust? Is it an irrevocable trust? Those two things are going to have key components to determine whether or not it's really an asset that is subject to division or not. Then we're going to look at distributions. So if this person is the beneficiary of a trust, so for example, Erica, you're the beneficiary of a trust, and say it's an irrevocable trust, but also let's say that you are given $5,000 every month because that's what the trust says. Congratulations, that's income to you. It also may very well be assets to you that are subject to division. So we may have to look at it, we may not. But let's just say that again, we look at it and Erica, you say that upon your 40th birthday, you're going to get all of these assets. Well, if you're 39 and a half, guess what? That's going to be subject to a division of assets. And immediately upon your 40th birthday, you're going to get that, which again would be subject to a division of assets under the divorce. So we have to look at the big picture. We have to look at those trust documents. It's not a cut and dry, this isn't mine and I don't have to worry about it. People that say that generally are people that don't have any idea and they were told that by somebody and they're just going to believe it. The reality is your assets may not be protected or they may be. But again, we have to look at all those documents, look at how the money is being distributed, when it's being distributed, and what that's going to look like for you in the future.
Wow, I did not realize that either. So when the properties come out of the trust and they're given to you, then they are subject to division. That is definitely a gotcha. So, I mean, I can imagine that there are people that drag out their divorce knowing that their ex is going to be getting something in the near future.
It definitely happens. The problem is when you have one that's called like basically a discretionary trust, which is it's at the discretion of the trustee. When they decide to give you money, they'll give it to you. When they don't, they don't. So that's a little bit harder to discern because we have to kind of look at the history. Again, prior to the divorce, were you receiving this money each and every week or every month? Or had you not received any money in the last 10 years? Again, that's going to be something that we're going to have to look at on a case-by-case basis. But yeah, the end of the day is sometimes it is dragged out. And the other part of it is sometimes that person is like, let's get this done now because I know I'm going to get this money and we need to get rid of it. And that's exactly what their motive is. And again, the court is going to look at that and say, well, are you doing this for kind of fraudulent reasons? And big picture, maybe it's not an asset today, but maybe that's going to go toward alimony or child support or something else.
Yeah, I mean, I guess they can look at what you're going to be getting in the near future, and you can't say that you're poor if you know that you're going to be getting an extra $50,000 to $100,000 a year, depending on what's in that trust. That is so interesting. I think we could probably do an entire interview on that alone. But what if there is a prenup? I mean, we've talked about prenups before, and I mean, hopefully they're set up right, and that you can protect some of your assets that your spouse had nothing to do with. What happens then?
Well, I guess we have to start with the premises. Is the prenup valid? So if it is valid and the court finds that it's valid, then obviously whatever that prenup says is going to dictate. And generally speaking, there's language that says if I owned it prior to marriage, you're not going to get any portion of this, whether that asset has increased or not. But then we also have to look at, well, was there additional contributions? Is there language that provides for that additional contribution? Are there other assets that were individually owned prior to marriage, and then at some point they converted it to a joint. So it's probably, on the face of it, is whatever that prenup says is what's going to be held valid. But are there caveats? So again, we have to look at that document itself and determine if it qualifies, if it's 100% into this prenup, or if it has been modified based on the party's conduct. Now, of course, the obvious other answer is, if the prenup is not valid, again, we're going to go back to statements of, is it a marital asset or is it not? Is it a premarital asset? Is it not? And so we're going to have to do that analysis instead.
That makes a lot of sense. So, for example, if I owned a condo before I got married, and then, it increased in value, whatever, but I had a prenup, but then I used marital assets to redo the kitchen or redo the bathroom, then perhaps a piece of it would have to go to my spouse if we get a divorce.
That is correct.
That's amazing. Good to know. I mean, I don't think people realize what a huge financial decision marriage is. And these are some of the reasons why. So what if you obtained a large gift during your marriage? Is that also something that is going to be split? Maybe you even won the lottery. I don't know.
So the answer is, again, what kind of asset am I being given? If I'm given a house, my parents give me a house, and there's no mortgage on it. Again, is it a marital asset? Probably not, unless I then sell that house and buy another house with my husband. Then it now becomes a marital asset, and now at some point I've commingled funds. Let's just say, for example, that I'm given, $50,000 from my parents, and I put it in my bank account. Is it my bank account individually? Is it a joint bank account? Am I using those funds for marital expenses? Am I putting it aside and earmarking, going, this is my money from my parents and I'm not touching it? Well, if I don't touch it, then chances are it's not going to be a marital asset. If I start touching it, or I start using it and commingling it again, we're going to look at what are we doing with that asset. So that's a huge issue as to how we're going to treat it. Obviously, again, if it's something intangible, we may not worry about it as much. Again, it depends on what the value is and how we're treating it. Now, in terms of the lottery, again, it kind of looks at, where are we in the relationship? Is this the week before we get divorced? Or is this, halfway through our marriage before we're getting divorced? And again, what are we doing with those assets? We won $100,000 on the lottery. Okay, where does that money go? We went to the casino together and we gambled, and it just happened to be that I pulled the slot. Well, is it a marital asset or is it your individual? Chances are that's probably a marital asset. So again, where is that money going? Where is that coming from? How do we acquire that money? Because I put this money aside, and every week I go buy 10 lottery tickets, and that's my money, that's my play money for whatever I want to do. Is that a marital asset? So again, we have to look at it big picture here. And unfortunately, I'm never going to be able to give you every scenario that's going to come up. So if you have these situations, you definitely need to come see me, because I can play the switcheroo game and I can make an argument either way. But at the end of the day, I need to know the specific facts in your case to determine whether or not it's a marital asset or whether or not it's not subject to division of assets.
Yes, do go see Nicole if you have any questions about winning the lottery while you're going through the divorce. And for plenty of other reasons, as we've stated. I'm just joking around a little bit, but I'm definitely going to make sure that if I get married again, I go to the casino alone. And anyway, so I know that inherited assets can also be a situation that people wonder about, because I know people whose parents died just after a divorce, and not only is the other person bitter because they had to split up half their assets, then all of a sudden their spouse is doing exceptionally well, but that's all about good timing, right?
Absolutely, it is. I think that's the big picture. Again, we're going to look at what that scenario looks like. I've been married for 10 years, and my parents passed away and they give me all of their assets, and maybe it's $200,000. Again, what am I doing with that money? Did I put it toward my house that I now own outright because I was able to cash in their money? Did I put it in a separate bank account? Kind of along the exact same lines as a gift. But let's take the other scenario where it's a 10-year marriage and they die just as we're going through a divorce. Now what? Now, well, wait a minute. It's not necessarily a marital asset because you didn't do anything with it. You didn't really earn it at the end. So maybe we exclude it. So again, we have to look at that big picture. Obviously, the longer the marriage goes on in relationship to when these assets were given to you, chances are it's going to be a marital asset. So again, I get it 6 months after I'm married, and I'm married for 20 years. Guess what? Unless I earmarked it and have never touched it, it's a marital asset. It's going to be commingled in some way, or whatever the case may be, whether it be renovations on the house that you've used to purchase it with, whatever the case may be. I'm sure your husband, whoever, did upgrades on the house, so now again he has to do something as a contribution as a homemaker. Those things are going to come into play. So the longer you're married in relationship to when you got it, chances are it's going to be a marital asset. The shorter it is, so i.e. somebody passes away 6 months before your divorce is final, chances are they're not going to get any of it. Maybe if they get anything, you're looking at maybe 10%-ish. But again, the other part is in the middle of the marriage, and you can identify it. I use it to pay down this loan. And then when I did that, I also paid down this. And I can follow the trail of where it went. Maybe then it's only considered 25%. So we've got all these numbers and all these percentages that we can use. And at the end of the day, again, it's going to go back to your specific case. But can it be considered a marital asset? Absolutely.
Oh my gosh. I'm so glad mine is over. There's still obviously issues that come up, but I mean, it's such a stressful situation, and your clients are very lucky to have you because you're the voice of reason, and you also know everything that you need to know about this. So if you're going through a divorce, definitely give Nicole a call because it's definitely some rough terrain sometimes, and it can be tough for a trained professional, never mind someone that's never been in this situation, never been in a courtroom. And this is a situation too. I hear some crazy things when it comes to pets. There's pet visitation. There's, I don't know if there's support for pets. Like, what about pets? They are your family members.
Oh, pets are always a touchy subject. It's one of those things that, yes, a pet is personal property. Therefore, it is subject to division of assets. Now, how do you divide a pet? You don't. That's the bottom line. So the question is, who's going to get the pet? What are we going to do? Does that pet have a value? Well, again, we all know that at the end of the day, unless it's a breeding animal, the value is nominal at best. So the question is somebody so stuck on that asset and that personal property that they want it? And sometimes it's for the wrong reasons, sometimes it's for the right reasons. Obviously, I put in language that says, hey, the pet is going to be owned by the parties jointly, and it's going to go and travel with the children. That's kind of the easiest way to deal with it. And then we have to put in caveats that says, hey, both parties are going to be responsible for the cost of, the vet bills, and they're both going to be responsible for their own food and stuff of that nature. Then we get into a little bit more complicated situations where, again, we don't have children and we're fighting over the pets because they're pets or they're children. And how do we divide that? Then we have to look at, again, who's paid what. Again, this dog may be in your name, but it may not be owned by you. It may love your husband more. It may be attached to your husband more. It may, not necessarily like you. There's a lot of factors that go into it. So again, we're going to look at that picture. I will say that the biggest issue from my perspective is being able to tell the parties that they're not allowed to euthanize. Why do I need to say that? I have no idea. because I can remember fighting over the pets ad nauseum, and it would not stop. And we finally got an agreement. And the moment the husband in this particular case got the pet, next day the dog was euthanized. It was out of spite. That is the only reason. But again, you spend how much money on attorney's fees just so you can have the dog euthanized, just so you can screw your ex? Really? So now we have to put in language that protects the animals, because really we should not be having this conversation, but this is how bitter and nasty some people get. So we do have to come up with creative ways. Sometimes we put in information to say the parties are going, mom's going to have the dog. However, dad's going to have parenting time with the dog. And we've done that. I mean, again, it's a unique situation, and in the end of the day is, you can't cut the dog in half. They're a family member, hopefully, and that you want them for the right reason. So again, what does that look like, and who's going to get that animal? And that's kind of a hard thing to do, because now you're playing on emotions.
I mean, that is hard, and I feel like that person should be going to jail for euthanizing that poor dog in a divorce case. I mean, you can't do that to children, and dogs are like your children for sure. So wow, I'm really sorry to hear about that, but that's why you need a good attorney that is going to make sure that they put that clause in, just in case somebody's very, very bitter and knows that that's something that's going to hit that their ex-spouse hard.
Yeah, I think it goes back to, the other statements where, again, when we're talking about personal property, we're finally dividing the personal property. I mean, I'm talking the real personal property, the bureaus and the dressers and, the John Deere tractor and all those things, right? I also now put language in there that says it's going to be in the same working condition or in the same shape, because again, I'll give it back to you. I'll give it back to you in pieces. Let me see how you like that. And it's completely destroyed. Or, somebody's literally taken an axe to it, or they've let it sit there in a moldy basement. There are tons of ways that people can be vindictive. So again, a good attorney is going to be able to put in language in there that's going to at least give you the best bang for your buck. Obviously, I can't stop people from being stupid. I wish I could, but at the end of the day, at least I can protect you when they are stupid, that we do have a remedy available.
Yeah, I think I told you that happened to me once. Someone was it was a business situation, but I had bought some furniture, and it was lovely furniture, and I paid a few $1,000 for it, and the woman just gave me back completely different furniture. Yeah, it was a futon. It was not the high end situation. There were really nice file cabinets and everything that I had bought, but they were like, $20 file cabinets that she gave me back, and they were old, and I rented a U-Haul and everything, and I went back empty because I was like, Jesus. So yeah, and I represented myself in that case in small claims court. I want to thank you so much. This has been quite the eye-opening interview, and we're trying this out at our new time when we first open our eyes in the morning, and we want to talk about legal stuff. Thank you so much for joining us, and for the very interesting topics. We really appreciate your time, and we look forward to the next one.
Thank you.
You are welcome, and thanks everyone out there for watching. We look forward to seeing you in our next episode. Have a wonderful day.